योगः कर्मसु कौशलम्.
Namaskar. I, Dr. Anjali Hastak, thank UGC, Human Resource Development Center of Gujarat University, for giving me an opportunity to connect with you all and deliver my session on family law on marriage and divorce, a comparative perspective with reference to Uniform Civil Code. I thank Professor Dr. Jagdish Joshi, Professor and Director of UGC HRDC of Gujarat University. I also take this opportunity to thank Dr. Bhavesh Bharad, who is coordinator of this RC program, and Dr. Vijeta Singh from Jalgaon Law College for introducing me with the organizers. I am really happy about the HRDC Gujarat University has coordinated with e-contents creation training which they have imparted not only to the professors but also to the administrative staff of the university. They are getting funds from RUSA. Their website UGC HRDC Gujarat University is very dynamic, and the journal of UGC HRDC Gujarat University is indexed in Crossref and DOI. It has MOU with UK and Canadian universities, and it invites international resource persons and also give consultancy. So altogether it is very innovative and established training center, and this is entirely a teamwork, and I am really thankful that I am now part of this particular training center. So friends, now let us start with the session, which is with respect to the family law on marriage and divorce, a comparative perspective with reference to Uniform Civil Code. So let us see what are the contents of this session. First is about the historical aspect of divergent personal laws which were there. Secondly, the comparison of personal law on legal profession on marriage. Then the comparison of family law on divorce laws, and the need of Uniform Civil Code. Let us see one by one the provisions which are given under these contents. So starting with the historical aspect of divergent personal laws. Friends, we all know that in a primitive age, men and women behaved like birds and beasts. This is my first statement. And secondly, I am saying, since the Vedic period, marriage was a well-established institution. Now you can see the difference in between these two statements itself, that in primitive ages, men and women behaved like birds and beasts. So what was the condition at that particular time? Total anarchy was there, and then there was no well-established marriage institution which arose only in Vedic period. So since Vedic period, we are seeing that there was marriage institution which was taking shape. That is the sacredness of marriage, the monogamy, the relationship of son and father to give funeral oblation, that was being recognized in this Vedic period. And matriarchy and polyandry was rare. Family ideal was very high during Vedic period. And the Vedic text speak about the honored and respected position of wife. When she used to enter after her marriage in her house, her father-in-law used to give blessings to her to become the queen of the household, to become the mother of heroic children. Now when the Chaturvarnas were getting established, intercaste marriages were very rare. Family ideal was very high. The Vedic text speak about the honorable position of women when after the marriage, when wife used to enter the house, she used to get blessings from her father-in-law that you become the queen of this house, you become the mother of heroic children. Chaturvarnas were getting established, intercaste marriages were rare. remarriage of a widow was permitted during those days. Even the widow, with the permission of elders in the house, was allowed to marry brother of her husband for the creation of children. And in unapproved forms of marriages, divorce also was allowed. Standard of female morality appears to be very high. The chastity of woman was respected and also was protected. Now, adultery was considered as a serious crime, and adulterous wife, and if a son is born out of such behavior, they used to get expelled out of the society, and they used to get only bare maintenance for such behavior. Now, basically the desire was for a legitimate son, aurasa putra, and later on even the adoption of a son also was permitted. Now, as years went on, centuries went on, we see the jurists like Vidyaneshwara, who founded the Mittakshara school, and Jimutavahana, who founded the Yavaga school. They shaped and molded these laws, which were given in various texts. Now, as the time passed, we see prior to the arrival of British period till 16th and 17th century, as there were sub-schools which were developed in various parts of India, where they basically follow Mittakshara. But then they changed these laws as per the necessity in their various regions. So we basically see that the laws were getting changed with respect to marriage, with respect to other matters related to life, in the life of Hindus. But as British people arrived, this flexibility stopped because of the authoritative precedents, decisions which were given by the British judges, and then there was lesser growth of laws. If we see parallel, the four sources of Muslim law, the first is naturally Holy Quran, which is the scripture of Muslim people, where about 6,000 verses were given to Prophet Muhammad by angel Gabriel, which were still being followed for many centuries. Secondly, Sunnah, that is the principles of Quran. Thirdly, the Ijma, that is the conscience of the jurist, valid as per the principles of the Quran. And fourth one is the Qiyas, that is analogical deduction from the comparison of other three sources. Now, this policy of non-interference into the personal laws of Hindus and Muslims was continued for about 200 years. But then later on in 1775-76, Warren Hastings undertook the work of codification of Hindu law, where the ancient texts were collected, modern texts were collected, and with the help of Pandits and Shastris, they were first translated into Persian and then into English, and it was known as Gentoo laws or Gentoo code, which had civil laws, criminal laws along with the personal matter. Same thing happened with the text of Muslims, which were originally in Arabian language, were converted first into Persian and then into English, and they came to be known as Hidayah or guide. Now, with the help of these texts which were translated into English, British judges started administering justice over these natives, and our original texts were practically thrown into dark since this particular period. Now, English people, they could interfere with Hindus but not with Muslims, as their attitude of non-interference with Muslim was greater, and they could not change the traditional laws of Muslim much to bring them or mold them as per the time. Now, during this time, legislative reforms were enacted during British India, and they were really helpful, and they really marked the beginning of some modern era. The Caste Disabilities Removal Act was legislated in 1850, and first time it was permitted that even a Hindu person gets converted to Muslim or Christianity. Because of this legislation, he can retain his interest in Mittakshara property, which was not allowed earlier. Or Hindu Widows Remarriage Act of 1856, when Hindu widows were allowed to remarry and the child of such marriage was also considered as a legitimate. The Child Marriage Restraint Act 1929 restricted child marriages, and Hindu Women's Right to Property Act 1937, through which the Vitakshara rule of survivorship came to an end, and as per this act, the property of a co-partner started getting to the widow after the death of this co-partner. Even under Muslim law, the Muslim Personal Law Shariat Act 1937 was legislated, which restores the Muslim traditional law of Muslim. And dissolution of the Muslim Marriage Act 1939 gives Muslim wife the right of judicial separation from her husband in circumstances. Now next, coming to the period of 1947 to 1950 was really a catalytic period in which catalytic changes took place in India, as there was work of rehabilitation of millions of people who were migrating from Pakistan to India. The new constitution was introduced on 26 January 1950, and first parliament also came into being under our constitution. Now during this period, Hindu Code Bill was introduced by Shri B.N. Rao committee. Many changes were introduced in the traditional Hindu law. There were equal rights given in property to the daughters along with the sons. There was right given to the Hindu person to adopt a daughter. There were many changes which were brought in institution of marriage under this Hindu Code Bill, and naturally our society, Orthodox society, went against this, and then it was not possible at that time to make the legislation for this changed circumstances and make laws for the equality of men and women. But later on, this particular draft bill was read clause by clause, and then 4 enactments were made out of it. Out of this, first was Hindu Succession Act, then Marriage Act, and law on guardian laws on adoption and maintenance were made out. So the Law Commission's report on this says that basically there are 2 fundamental assumptions when the Hindu Code Bill was given. The first was that the personal law cannot be treated as part of the religion, so-called. And secondly, Hindu law was never static. It was changing from time to time, and the changes were taking place from so many years. If we consider, as in this particular session we are going to speak about marriage laws, Hindu Marriage Act, which was legislated, had many changes which were brought, as that was the time during which the socio-economic changes were taking place in our country, and these changes were introduced in law so that there will be equality among men and women of Hindu religion, Hindu society. So basically there was abolition of Mitakshara. Now because of codification of Hindu law, many things happened. Firstly, there was certainty and simplicity. Law became uniform throughout the country and became more liberal and suited to modern society as per the needs of the society. And lastly, there was reformative spirit. This was not there initially, as there was no simplicity, there was no uniformity, as laws were as per the schools and sub-schools of Mitakshara. Everywhere the laws were changed and there was no uniformity. So because of codification, as was given by Hindu Code Bill, when it was converted into 4 different legislation, law became very simple, it became very certain, and there was mainly uniformity. Now what were these changes with respect to Hindu Marriage Act? Entire institution of marriage now was based on this codification, where the judicial separation, then capacity to marry, restitution of conjugal rights, The grounds for divorce were given for the first time, in which desertion and cruelty, and that too mental cruelty, were given as the grounds. Now these laws were made applicable to all the Hindus. At this particular time, there are various people of various religion are living in our India. There are Hindus in majority, there are minorities, Muslims in minority, there are Parsis, Christians and Jews, and they are all living with their traditions and customs under one national flag. This is definitely the matter of pride for us. But then ours is a secular country as per our constitution. Now who are Hindus? All those born as Hindus definitely are Hindus, but along with them Sikh, Jain and Buddhist by religion, they too are included into the definition of Hindu. All their converts and reconverts, or where one person to the marriage is of these particular religions, then provided the child is brought up as Hindu, he also is Hindu, including the legitimate and illegitimate children of such persons. Not only this, also those who are Muslims, who are Christians, Parsis, Jews, who are domiciled in India and to whom no other law applies, they also are included into the term Hindu. And to all these persons, the Hindu Marriage Act 1955 becomes applicable with respect to their problems of marriage and divorce. Now who is a Muslim? Naturally the one who is by birth, by religion, and also who is converted to Islam by formal ceremony of conversion, is governed even today by uncodified Muslim law and also those legislation which are legislated for this particular religion. Parsis are the person came and settled down in India from Persia, belonging to Zoroastrian faith, and in modern India, Parsi law applies to persons who are even descendants of such persons, and those who are immigrant, and they are governed by Parsi Marriage and Divorce Act. Christians are those who, as per, are the who profess Christianity in any of its form, and also the descendants and converts are governed by Christian Marriage Act for these particular purposes, and the Jews are even today governed by uncodified law of their. Now let us compare personal laws, all personal laws on legal provisions of marriage. Now as we know, there is multiplicity of personal laws, and they are existent even today. Let us see what are the legal provisions with respect to the marriages in all these laws. Let us have just a bird's eye view and let us reflect on these laws. Let us see what are the similarities and let us see what are the differences from the point of view of the future happening in our country about implementation of Uniform Civil Code. We all are educated people, and this particular RC program is basically for law teachers. We all are aware about the laws, so we are not at all going into the details of every aspect. Let us just see what are the similarities and what basically are the differences. Let us just compare. Now we know Hindu marriage is a necessary sanskar, a sacrament, and basically implies the permanent and indissoluble union of husband and wife. But since the Hindu Marriage Act 1955 is legislated, there are certain aspects which give the capacity to marry. What are these capacities? What are these virtues? First, those persons who are undergoing marriage must be of particular age which is given. They must be able to give consent. There should be mental capacity for marriage. Now, with the introduction of these elements, our concepts of marriage, Hindu marriage as being only a sanskar is changing, and it is shifting towards the concept of this as a contract which is there under all personal laws. Under Muslim law we know there is a proposal and there is acceptance is a pure ingredient of contract. Under Parsi laws, it is a Ashirwad ceremony and it must be carried out in front of two priests, but it is basically a contract. So is the case under Christian law and Special Marriage Act, which is legislated in 1954, where two persons, man and woman, from different religion can marry. That also is basically a contract. So you see similarities under all personal law except Hindu law, where Hindu marriage is considered as sanskara, but it is shifting towards, basically because of the ingredients of a valid marriage, it is nowadays is being considered as contract. Now what is capacity to marry? A man and a woman to become husband and wife, there are certain essentials which must be fulfilled. First is monogamy. For last so many centuries, Hindu persons, they enjoyed polygamy, not even limited to certain number as is there under Muslim law. Their polygamy is still there and they can marry 4 wives at a time. Now this monogamy was the first time introduced at 1955 when this Hindu Marriage Act was legislated. And now since 1955, if any person, any spouse has committed a bigamy means where during the lifetime the spouse gets married to other person, or even before giving divorce he gets married for the second time, even during the times when the first marriage is valid. Now this bigamy is now punishable under IPC. Here let us reflect and see that only Hindu wife or Hindu spouse is allowed to file a suit in case of the bigamy. Then why such conditions are not there for Muslim wives when polygamy is still there and her husband can marry for 4 times during the marriage? Just have this particular question in your mind and then we can proceed further. Age. With respect to age, no male can marry below the age of 21 and no female can marry below the age of 18. Now this is there under all the personal laws, but under Hindu law, this particular marriage is neither void nor voidable, but it is punishable. Now recently, also in 2006, a Child Marriage Restraint Act was passed. Initially in 1929 it was there definitely, but now this is irrespective of religion. The children of any religion, they can be restricted getting married below such age. In Muslim law we know that even though these children, those who are getting married, if they are below age, they can marry under the presence of the guardian to marriage, and such marriages are considered as valid. Now under Parsi marriage laws and under Special Marriage Act, if the parties to marry are below age, such marriages are void. Let us take this particular point in consideration, that under these two religions, under Parsi and under Special Marriage Act, if the children are getting married, those who are below age, then their marriage is void. Mental capacity is another criteria for valid marriage, in which as per law, marriage under Hindu law and also under Special Marriage Act, neither party is capable of giving valid consent to the consequences of unsoundness of mind, or though capable to such an extent as to be unfit for marriage and for the procreation of children, or are subjected to recurrent attacks of insanity or epilepsy. This is since the amendment in Marriage Act 1976, this particular clauses are inserted in this section. So having mental capacity is very much essential for giving consent to marriage, and similar laws are also there in other personal laws except in Muslim law, where the insane person is basically considered as a minor person, and then they can marry with the consent of guardian to marriage. Prohibition on amount of relationship by blood or affinity. these are the provision where it is provided that Sagotra and Sapinta marriages are void under Hindu law, where there is a relation from mother's side 3 generations and from father's side 5 generations. If such relations, if these parties are lineal ascendants, then such marriages come under the category of void marriages. Even there are prohibited degrees of marriages like 2 persons when they are brothers and sisters, uncle and niece, aunt and nephew, they cannot marry and they come under prohibited degrees of marriages. Such marriages are void. So is the case under Muslim law also, where consanguinity, affinity, foster relationships are considered as prohibited degrees. Now, ceremonies of marriages under Hindu law, we all know Kanyadan, Vivaha Homa, Saptapadi. These are considered as essential ceremonies of marriage. Kanyadan, with this word now we know that there are voices of female agitators that no one should give daughter as gift. Kanyadan should be avoided, that is what is the voice. But then this takes place and it is considered that Saptapadi, that taking 7 steps around the fire is considered as very obligatory, very essential ceremony, and marriage is said to be completed on 7th step. And this is basically necessary for proving the validity of marriage in case of bigamous marriages if the matter goes into court of law. Under Muslim law, we know that there should be proposal should be made by one party and it should be accepted by another party, and that must be done within one sitting at the same time, and it must be in the presence of 2 adult male or 1 adult male and 2 adult female members. It should be done, and this is necessary under Sunnis, but under Shia's laws such witnesses are not necessary. Parsi laws speak about the ceremony of Ashirwad that must be performed in presence of 2 witnesses, in presence of religious priests, and registration of marriage is very much essential under these laws. Similar is the case with Christian laws, where marriage minister of religion, marriage registrars and persons who are licensed to authorize the marriages should be present. Now, in case of special marriages, there is basically the entire procedure that must be taken place, like there must be notice should be given, then it must be raised for objections, and then everything as per the procedure must be taken, because this is the matter of marriage between 2 persons who are of different religions. So all these ingredients with respect to valid marriages are fulfilled, then the marriage is called as a valid marriage. So what is valid marriage? It is a marriage which confers the status of husband and wife to the parties. It confers the status of legitimacy to the children, and from such marriage there arise mutual obligations and also certain rights which flow from marriage, which is not the case in case of void marriage. Void marriage is void ab initio. It will be considered as not at all in the existence in the eyes of law. No consequences follow from void marriages, and basically there is also need to get it annulled by the decree. This is not the case with voidable marriages. Voidable marriages are valid till they are not avoided by the parties to the marriage. So if voidable marriage is valid, all the consequences of valid marriage follow from it. But if the voidable marriage is annulled by the decree of nullity, then the children of such marriage and also the children of void marriages, they are considered as legitimate, but then they inherit only to their parents and to not other people, not other relatives. Same is the case with Muslim law. On certain grounds which we have discussed already, voidable, valid marriages, these differences are there, but under Muslim laws these are peculiar to their text, to their traditional laws. Voidable marriage with respect of Hindu law, Hindu Marriage Act gives special certain grounds for voidable marriages, and firstly, if there is a failure to consummate the marriage owing to the impotency of the respondent this becomes voidable marriages if the other party, the petitioner, or other party to the marriage has decided to be in the marriage and not avoided the marriage. In case of Parsi Marriage Act, this becomes the ground if there is willful refusal to consummate the marriage. Incapacity of the respondent, which we have seen just now, also is the case, but in Special Marriage Act and Parsi Marriage Act, this becomes the ground for void marriages. Then if the respondent wife, if she is pregnant at the time of marriage, about which the petitioner is not aware, and he is not the cause, and he brings the petition in the court of law before the expiry of 1 year since the solemnization of marriage, that also is the ground for voidable marriage. Force and fraud, if there is force, if there is fraud that is committed which is material to the fact of marriage, since from the 1 year, particular period of 1 year is given since the force has ceased to take place and the fraud has been disclosed, the parties can get their marriage annulled. Now, with respect to Muslim laws, there are special grounds for voidable marriages which are peculiar to their traditions. Where there is a marriage of a woman who is undergoing iddat, or marriage is in violation of prohibition on the ground of different religion, or marriage is performed without permission, or marriage is with fifth woman. These are the grounds under Muslim law. Now let us come to the next point of our discussion: comparison of family laws on divorce provisions. Now, as we have seen in the early days, only adultery was the ground on which the wife used to get expelled out of the society. Initially it was not at all allowed, and we know that only after 1955 when marriage law was legislated, first time this provision, the various grounds of divorce were given. However, marriage is very much recognized as a social institution, and basically it is seen that there should be harmony, there should be love and respect in between the parties, but happening of certain things because of which you cannot avoid the breaking down of such marriages, and therefore it is necessary that such grounds should be given, so that in case of any danger, in case of any happenings which are not needed in family, needed in the relation between husband and wife are there, then such grounds should be made available. Let us first see what are the provisions under Muslim laws. We know that the provision of divorce was there, which was recognized by the religion right from beginning, and it is the first country we can. It is the first religion in the world which has expressly recognized the termination of marriage. Now, the husband under Muslim law can announce the talaq and get divorce at any time, but so is not the case with Muslim women. Muslim women still get the right, as Prophet Muhammad has provided, that if she is desirous of judicial separation on happening of certain grounds, certain things, she is entitled for getting the divorce from her husband. So Muslim wife also can, if she is desirous, can take the divorce. She can basically purchase the divorce, which is known as tafweez. Now, if husband gets the divorce, she has to maintain iddat in case of the death of the husband. But during the lifetime of husband, she needs the consent of her husband prior to getting this divorce. So is not the case with husband. He can anytime pronounce this word talaq and get the divorce. And after divorce, he can even immediately remarry. There is ilam, which can be performed by Muslim husband. That is when he declares non-cohabitation with wife, and when he is sound and when he is an adult person, he can do so. Or there is zihar, where he compares his wife with mother or other women of prohibited degrees relationship, and can declare the talaq. Talaq ul sunnat, ihsan and hasan, these are most approved forms of talaq, as there is always the time of reconciliation is given in these particular talaq. But talaq ul biddat is the most disapproved mode of talaq, where the husband pronounces 3 times about divorcing his wife, which is recently we know that has come under the hammer of Supreme Court, where under in Shaira Banu's case 2017, the constitutional validity of this triple talaq was considered by the Supreme Court, and held that the exercise of triple talaq by Muslim husband against his wife in one go is arbitrary and unjust, and therefore violative of Article 14 of the Constitution. The Indian government, on the direction of the Supreme Court, has even legislated an act, Muslim Women's Protection of Right on Marriage Act in 2019, where now Muslim husband who uses this triple talaq shall be given punishment of 3 years of imprisonment, and therefore he is barred from pronouncement of triple talaq henceforward. For other personal laws in India, there are basically 3 theories of divorce. First is the fault theory of divorce. If there are faults, which are these faults? Like parties to the marriage has committed adultery, or there is cruelty or desertion. Happening of these faults naturally will lead to the breaking of the marriages. There will not be any mutual love and respect in the parties, and therefore if these faults are established, if these grounds are there, the parties can get separated from each other. Secondly, a consent theory is there, where there is both the parties, even if there are no faults, parties to the marriage by consent from each other, they can get separated, which is there for all the personal laws in India. In Muslim law, there are 2 different ways in which this consent theory becomes applicable. First is khulla, where the wife can apply, can ask for setting her free from husband, and where husband becomes ready to set her free, that is khulla. And second is mubarak, which is for both husband and wife. They with mutual consent can decide to get separated. Now under Hindu Marriage Act and Special Marriage Act, there are procedure, there are steps to be taken by the parties to the marriage, where they need to apply in the form of petition for getting separated under this particular theory, and they need to stay separately for about 1 year and more. And furthermore, stricter procedure is that at least 6 months must have passed before the court decides to give them consent, to pass a decree for the separation, and can pass the decree of divorce if the court finds that there is truth in their statements. Third is breakdown theory, when there are no faults, when there are no mutual consents, and there are certain things where it needs that they cannot at all stay with each other. In such cases, this breakdown theory becomes applicable, and the parties can get separated from each other. Now, judicial separation is a lesser evil as compared to divorce. As we know all, that judicial separation, even if the decree is passed, they still remain as husband and wife, and if one of them dies, the other one can succeed to the property. So is not the case under divorce. After passing the decree of divorce, they are no longer as husband and wife, and if any one of them dies, there cannot be succession to the property of other person. These particular grounds for judicial separation are almost same as those are under divorce, and they are also available under all the personal laws. You can see the similarities which are there under these particular provisions of all personal laws. Restitution of conjugal right is the remedy which is given to the parties where they are becoming where they wish to get separated because of the petty reason, and the chance is given by giving them chance if one of the parties to the marriage. So under Hindu Marriage Act, under section 9, it provides that where husband or wife has without any reasonable excuse has withdrawn from the society of the other, then the aggrieved party can file a petition in the court of law asking for restitution of conjugal rights, and the court may, being satisfied on the truth made in the statement, can pass the decree of restitution of conjugal rights. So here the section provides that the proof that there was reasonable excuse, and for that particular reason the respondent has left the society of the other, will always lie on the person who has withdrawn from the society without any reasonable excuse. Now these grounds are available under all the personal laws. So this particular similar remedies are available under various personal laws. So now let us see the various fault grounds which are available under various personal laws in India. The first one is adultery, which is a ground for divorce as well as for judicial separation. Now under various personal laws, the phrasing that is done is different. Under Hindu Marriage Act and under Special Marriage Act, the wording is that the respondent, since the solemnization of marriage, had voluntary sexual intercourse with any person other than his or her spouse. Then under Parsi law, it says that since the marriage, the respondent has committed adultery. Under Divorce Act, it says that the respondent, since the solemnization of marriage, had been guilty of adultery. You can see the difference in the phrases, which are the way the fault is worded. Under Hindu law, it must be voluntary. Under Parsi law, it must be committed. The adultery, the crime as such, must be committed. That ground should be available. And under Indian Divorce Act, it says that the person must be guilty. These are the various stages as we can understand. And if we try to find out similarity, the similarity is only when the ground of adultery is available, provided at the time when it goes into the court of law, as per different religions, as per different personal law, it has to be proved into the court of law. Secondly, the ground is desertion. That there must be factum of separation. Then there must be intention basically, animus deserendi must be there to get separated, to desert the spouse. And it must be without consent of the petitioner. It must be without any reasonable cause. And under certain laws it must be for 2 years. Otherwise the ground is similar for persons to the parties under various personal laws. Under Muslim law, this particular ground as desertion is not available, but the law says the husband has failed to perform marital obligation. Now here, failing of husband to perform marital obligation is considered equivalent to desertion. Cruelty, as we know, is naturally available as a ground of divorce under and also for judicial separation under all the personal laws. Only in Muslim law, it is as per their traditions and as per their religion that husband has habitually treated her with cruelty, where husband associates with women of ill repute or leads infamous life, attempts to force her to lead immoral life, or dispose of her property, or obstructs in her religious performances. If he has more than wives, more than 4 wives, and then he doesn't treat them equally, that these are the grounds for cruelty under Muslim law, which are peculiar to their traditions and their traditional laws, which are restored since so many years. But otherwise, cruelty as a ground is available in all personal laws, whether it is physical cruelty or mental cruelty. Basically, mental cruelty is very difficult to define, but then if things have happened in such a way, then if the case is before the court, then it is the discretionary power of the court to decide whether mental cruelty has taken place or not. So it will be the duty of courts to decide, to see as per the facts of the cases, that what are the backgrounds of these parties, their education, their bringing up, their traditions and customs, the way they behave with each other, that shall be seen by the judges, and then it will be at the discretion of the court to decide to give this particular ground to the parties for dissolution of their marriage or for judicial separation, as the case may be. Then insanity. If the respondent is insane, for these also the certain phrases are given under various laws. Under Special Marriage Act, under Hindu Marriage Act, it has been said that that the respondent has been incurably of unsound mind, or has been suffering continuously or intermittently from mental disorder of such a kind and to such an extent that it cannot be reasonably expected to live with the respondent. Now here, what is mental disorder, what is psychopathic disorder, which are explained in laws. So basically this particular ground is available to all the persons under various personal laws. Now the diseases like leprosy is a ground for divorce and judicial separation under most of the matrimonial laws. Under Hindu Marriage Act, it is said that respondent is suffering from virulent and incurable form of leprosy, then that will become the ground. Under Special Marriage Act, respondent has been suffering from leprosy, and under Muslim marriage, that husband is suffering from leprosy. You can see the differences. Like under Muslim law, it is available, the ground is available for wife when it is referred as the respondent only as husband. And under Special Marriage Act, the act says that the respondent has been suffering. It means if it is proved into the court of law that the respondent is suffering, then that is the sufficient ground. Whereas under Hindu law, the respondent must be suffering from virulent and incurable form. Here you can see that the intention of legislature is to give the time to the parties, as because now is the time, in modern times there are various medicines which are available to the patient so that it can get cured, and so that there can be the possibility of saving the marriage. So basically these differences you can see that the wordings, the phrases in sections can make the changes. Similarly, having venereal diseases like which are in the communicable form, that also are the grounds, and they too are worded differently. Like in Muslim law or in Parsi law, it is said that it must be that the petitioner must be infected by the respondent. These are the requirements. Conversion to another religion is a ground, which is definitely if under Hindu law or Parsi law, if Hindu ceases to be Hindu or a Parsi ceases to be the person of this particular religion, then this ground is available. Now you can see the difference under Muslim law. It is said that they have used the word apostasy, not a conversion, and it is provided that the moment husband expresses, it can be expressed or it can be implied, but when he ceases to be a Muslim, at that particular moment itself the marriage gets dissolved and the wife can remarry even before the expiry of iddat, and she will not be guilty of bigamy. So under other personal laws, if one of the parties to the marriage gets converted to another religion, then that simply becomes the ground. It doesn't dissolve the marriage at that particular time. For that they will have to apply into the court of law. Of course, this will not become applicable to Special Marriage Act, because party to the marriage are already of different religions, and even they get converted to another religion, that won't be ground. Presumption of death. In case all personal laws, it is provided that if the whereabouts of the respondent are not known for the period of 7 years, then that becomes the ground. Whereas under Muslim law, it is this period is of 4 years. You can see the difference of 7 years in case of all and 4 years under Muslim law. 7 years of imprisonment also is the ground. Under all the laws it is provided that if the respondent is undergoing the sentence and he is imprisoned for the period of 7 years and more for any of the offence which is listed in IPC, that is more important, whereas under Muslim law only it is provided that the husband is undergoing imprisonment. That is the difference. Renunciation of the word is the peculiar ground which is available to Hindu law, and if the person leaves his family finally to enter the religious order, becoming yati and sannyasi, etc., that becomes. Now there are certain grounds which are available only to wife. Under Muslim law also there are grounds which are peculiar for women only. Under Hindu Marriage Act, under Special Marriage Act, Indian Divorce Act, they lay down certain grounds which under which only wife can sue for divorce. Under Hindu law, if the husband is guilty of certain grounds, like if he is guilty of rape, sodomy, bestiality, then that becomes the special ground available for wife. Second is, if there is polygamy, that is prior to commencement of this act in 1955, the husband has married more than once and the marriage is valid one, then the other wife can sue for divorce provided the wife of other marriage also is alive. So this is after the pronouncement of, after the coming into force of Hindu Marriage Act, this ground becomes available to such wives where husband has married more than twice, more than once, and where marriage is, both the marriages are valid. Now next, if there is non-resumption of cohabitation of the after the decree or where there is order of maintenance is done, or where there is decree of judicial separation has been passed but there is no cohabitation for the period of 1 year, or where there is a restitution of conjugal rights, these are all amendments made in the 1976. If it has not happened, then that itself becomes the ground for wives. Fourth one is the one to restrain the child marriage. That is, if the girl has married under Hindu law, if the girl has married when she is 15 and by the time she becomes 18, if she thinks about repudiation of marriage, then she can use this particular clause whether her marriage is consummated or not. Now similar ground is also available under Muslim law where girl as well as boy, when they were children and they got married under the guidance of guardian to the marriage, but then they have this option of puberty and they can they get their marriage dissolved under this particular section that is available to them. Now let us come to the last point of this particular discussion, that is need of Uniform Civil Code. Now we all know on 26 November 1947 we the people of India got our constitution, and through which we also received the concepts of fundamental rights and the directive principles of the state policy under part 3 and 4 of our constitution. As we know the differences, fundamental rights are justiciable and directive principles of state policy are non-justiciable. If the fundamental right is violated, one can go against it into the court of law and can get the justice. So is not the case under directive principles. Under this, Article 44 speaks about the Uniform Civil Code. Article 44 of Indian Constitution says that the state shall endeavour to secure for the citizens a uniform civil code throughout its territory of India. Now this article uses term state. It means Government of India, Parliament of India, governments and state legislatures of all the states, including all local and other authorities in India. The article says the state shall endeavor to secure. Now what is the meaning of this? It means that when this particular article was worded or when it was written at that time, the founding fathers of constitution were knowing about the obstacles which the future leaders are going to face, and therefore they have hoped that the future legislators or future executives would be able to implement uniform civil code or not. The expression used here is uniform and not common. It uses word civil, which is very elastic expression, which means private rights as distinguished from criminal rights or political rights, and which is derived from jus civile, which is the Roman term. And code means a comprehensive systematic body of law. Now what is the purpose behind implementation of uniform civil code? Naturally it is expected that this is to set ideal of secular society. It will do away with the diversity in matrimonial laws. It will make the Indian society homogeneous, and it will delink law from religion, and uniform civil code will contain uniform provisions for everyone based on social justice and gender equality in family matters. These are the aims, these are the objectives behind implementation of uniform civil code. Now we know, so far we have discussed, there are various personal laws and there are various provisions, but we see that every law suffers from deficiencies. On one hand we see that Hindu Marriage Act or Special Marriage Act, which are very modern one, where the concepts are very modern, but at the same time on certain provision there are archaic laws which are still there. In many countries we see that the personal laws are delinked from religion. In countries like Germany, China, Russia, United States, these are the watertight compartments, personal law and religion. Even the Muslim countries like Turkey and Saudi Arabia, they have worked tremendously on the foundation of the laws of Sharia, and they have modified their laws by giving more liberal modern laws to both men and women, and they are now shining as countries where most modern laws are being implemented and where the country is progressing day by day. So basically uniform civil code is being objected, and they say that uniform civil code is against the freedom of religion. They say that uniform civil code is against their cultural rights and their religious laws are immutable. But as we see under Article 25, there is right of conscience for everyone, there is right of practice and profess and propagate religion. Everyone has got the fundamental right to his religion, which is available to every person individually and not as per the community. Now, on international levels, uniform civil code is considered as a very powerful tool for empowerment of women. We know that under various personal laws, equality is not there. Certain rights are equally given, but under certain personal laws, there is difference. So if uniform civil code is implemented, all men and women, they will have equal rights, and therefore it will be definitely very effective way of empowerment of women, where they can raise up to higher level from the subservient position. Justice V.R. Krishna Iyer says about section 125 of Criminal Procedure Code that this particular section provides maintenance to infants, to children, to wives, to infirm parents irrespective of their religion. So there is nothing, anything, even though providing maintenance was initially seen as a personal law which was very much related to religion and honor. But under 125 of CRPC, now this is immaterial to which religion the party belongs. This is just a procedure and we can say that it can become applicable very effectively. Shri K. Munshi has said that there is nothing sacrosanct about the personal matters like inheritance, succession, marriage and divorce. So we can definitely delink personal laws from religion and we can apply them uniformly for all the religions. There is a very glaring example of state of Goa. You all must be knowing that Goa has applied uniform civil code in the state. Now those persons of various religions, all persons, Muslims, Hindus, Parsis, Christian, they get applied by uniform civil code. Now in this particular region, a Muslim cannot entertain polygamy. He will have to get applied by monogamy only, and therefore we can say that it is a very magical touch of uniform civil code is being applied on Goa. Now with respect to property rights, for which for many centuries we are agitating, the magic touch of uniform civil code is there, where when husband and wife, when they get married, whatever property they are having at the time of marriage, that becomes joint for them. And then in case of divorce, the entire property is divided equally, and in case of death of any person, half property goes to the surviving spouse and remaining is equally distributed among the children. You can see by this particular application, by implementation of uniform civil code in Goa, so many problems are solved because of this application of uniformity. You can see that various legislations are there which are irrespective of become applicable irrespective of religion of the parties. The Special Marriage Act 1954, two persons from any religion can get married, and then under this particular law, and then uniformly the laws become applicable for them. Hindu Code Bill, so it was so divergent prior to 1955. It has become so uniform. It has become so simple, and where it can be utilized by the people. Medical Termination of Pregnancy Act 1971, irrespective of religion, the provisions are there. Section 125 CRBC, which we have just now seen. Then Protection of Women from Domestic Violence Act 2005. Prohibition of Child Marriage Act 2006. They are all applicable irrespective of the religion the parties are. Then Maintenance and Welfare of Parents and Senior Citizens Act 2007, where the protection is given to senior citizens, to mothers, to father, irrespective of their religion, and then their protection is sought under this act. All these acts were passed by legislation without making any much noise about it and making them applicable to the persons of all religions. Irrespective of their religion, the laws are being made applicable. So coming to the conclusion, or thinking about all these points, so uniform civil code is not just a matter of gender justice, but it is also about how nation treats its diversity. It is about to reform practices offering protection to individuals who are right now having unjust laws. It is about balance between majority and minority. Definitely, nation will have to make a new code. It should not be the blend of existing one so as to prevent bias. And it is very much necessary that it must be imbibed on the minds of people that even if there is implementation of uniform civil code, everybody is going to have his right of religion. So for the progressive society, discarding something that is evil or which is detrimental, destructive to the society is the prominent need of the society. It's coming forward with the reformative zeal of discarding derogatory customs. Uniform civil code cannot remain a distant dream. Thank you.